lawyer or a deposition reporter like me, the three scariest letters in the English language are IRS. Hi, I'm Lisa Michaels, and guess what? I'm not here to sell you anything. Hopefully, I'm here to save you a lot of trouble. Because if you're a lawyer that works for a firm that books depositions, and like me, you'd rather not spend your time hanging out with the IRS, then you might just want to check out this brief video explaining how the way your firm books depositions could get you in trouble, very big trouble, with the IRS. So now I'm going to turn it over to our experts. Toni Pallone is, like me, a licensed deposition reporter. And she was one of the founders of DRA and serves as our legislative chair. Hi, Toni.
Hi, Lisa.
Ed Howard is one of California's most prominent public interest lawyers with a bunch of published cases to his credit in state and federal courts. He also served in senior staff positions in the California State Senate and serves as DRA's counsel and lobbyist. Hi, Ed.
Hey, Lisa.
So guys, how can a law firm get into trouble with the IRS just by booking a deposition?
A lot of the larger deposition reporting firms in the country, to try and drum up business, are offering goodies like bottles of champagne or gift cards or even trips or tickets to plays in exchange to secretaries, in exchange for the secretary or the paralegal giving them their business. Well, that's not a gift. The IRS conclusively deems that, according to the Hansen-Bridget memo, to be income. And it's unclear whether that income goes to the secretary or the paralegal that booked the deposition, or to the law firm itself that's employing the paralegal or the secretary, and the paralegal and the secretary is booking the deposition within the scope of their employment. So that's the way that you get into trouble. You get into trouble because the way that the deposition is being booked, the way that the secretary or paralegal is choosing one deposition firm over another, has to do with who's giving them the best goodie. And that goodie is taxable income in that quid pro quo situation, according to the IRS and according to the law firm of Hansen-Bridget.
I think in a lot of cases, too, the attorneys involved are not even aware that this practice is going on. Their secretaries, legal assistants, paralegals book depositions with these firms, take these kickbacks, and never report any of this, of course, to the attorneys that they're working for. So they could be caught very much by surprise at some point when they discover that there's been a considerable amount of income received by their assistants, their legal assistants, without their knowledge.
Well, what about the Christmas presents I drop off, or the pens and mugs I drop off at a law firm with my logo on it? Is that going to get the law firm in trouble?
Right. I think the Christmas gifts, the box of candy, the mug with your company logo on it is not the problem here. I think you have to make the distinction between those gifts where there are no strings attached and the ones where there are very clear strings attached, where it's you give me a depo, I give you this gift.
Exactly.
Those are the ones we have to be concerned about, Lisa.
Now, at some point, maybe the promotional gifts bleed into something that might be taxable, but those harder questions don't make this easier question any less easy to answer. If you've got a deposition reporting firm, and that deposition reporting firm is saying you get this thing of value in exchange for steering business my way, Hansen-Bridget and the law is real clear. That's income.
But if the secretary gets the bottle of Dom, isn't that income to the secretary and not the law firm?
The Hansen-Bridget memo analyzed that question specifically, and it said that the state of the law on that is uncertain. So if you're a partner in a law firm, it all depends on your appetite for risk and potentially make a new law when the Internal Revenue Code is concerned. On the one side, this is all happening within the scope of their employment. And so on the one side, the memo says the IRS could consider this to be income to the firm. On the other hand, it might end up being income to the secretary, but you know, it all depends on the law firm's appetite for risk and trying to let the IRS figure that out.
And I think there are even situations we've become aware of where secretaries, paralegals, legal assistants are receiving these gifts at their homes, at their residences, so that it goes unseen in their offices. I think that's something else that they need to be aware of. And sometimes these gifts over time can amount to thousands of dollars. So it's a very big risk they're taking.
Okay, well, besides the tax issues, are there any other problems with kickbacks in this situation?
The choice of a court reporter has to be made for the right professional reasons. You want to select the best reporter, the best services, perhaps the best price, but those are the things that should come into consideration, not what kind of gift you're going to get, what kickback you're going to get in exchange for giving a firm business. That's the important thing. To do anything other than that is detrimental to the case, to the attorney's client, and certainly to the profession of court reporting. You wouldn't want to know that a doctor was selected to do surgery on you based on how many gift certificates his office staff was getting.
Right.
And by the same token, you want to select a professional, a court reporter, for their professional services, not for anything else.
You know, as a lawyer, I mean, depositions and the transcripts are really, really, really important. They make or break my case. And most importantly, they're really important to the client. And the client deserves the best possible product.
Absolutely.
And when you're talking about a market that ends up getting all twisted up, not by rewarding the best possible product, not by rewarding the best, most reliable professional, but instead about who gives out the best, bottle of wine or the best theater tickets, that's not good for my clients. And as we know from the Hanson-Bridget memo, for me as a lawyer, it's not good for me as a lawyer either.
Fantastic. So Ed, if I were a partner in a law firm, and this is the most important question, how do I prevent my firm from getting into trouble with the IRS?
Well, the Hanson-Bridget memo is real explicit on that, and so is common sense. You simply need to have a very explicit policy that prohibits your employees from taking kickbacks or things of value in exchange for steering business anywhere, but specifically in the deposition area. So you need to have a really clear policy. Your employees need to be trained in that policy. And the Hanson-Bridget memo is also real clear that simply having that policy lay in an employee manual somewhere isn't enough when it comes to potentially protecting the law firm against the IRS. You've got to enforce that policy. So it's just basic common sense.
All right, so let's sum up. Here's some important points to remember about law firm employees accepting goodies in exchange for booking a depo with one deposition firm over another. The board regulating deposition reporters is suing a deposition firm for violating its rules on gift giving. The National Court Reporters Association completely bans firms that do this from advertising in their magazine. And worst of all, it distorts away from rewarding the best quality transcripts and the most reliable, professional, skilled court reporters. Tony, you get the last word.
Thanks, Lisa. My husband is a lawyer, and I think he's said it best. You would have to be nuts to let this go on in your law firm.
I'm Lisa Michaels for the Deposition Reporters Association of California. Thanks for watching.